Good evening, everybody. Welcome to Westgate Chambers Financial Remedy Seminar. Apologies for the slightly delayed start. Lots of cameras are off and people are muted. Please feel free to switch on your cameras if you wish to, but yes, do remain muted for now, but some questions later on. Thanks so much for joining at the end of the long working day. It's lovely to see so many names that we recognise, and we're also joined here by some friendly faces at night who we need to thank for hosting the evening. So starting the big question, fabricated documents, myth or reality? Affirmative, yes, absolutely. Unfortunately for all of us, definitely doctored documents, manipulated documents, tampered documents, tweaked documents, they are commonly now coming before us in our practice, and we're having to learn how to deal with them. I'm going to be leading with the relevant case law and my professional experience in this area, and then Laura is going to be leading with some more practical tips and hopefully an interactive lighter note to end the session. So, as I say, we seem to increasingly be coming across manipulated documents in our line of work, and having spent some time only briefly doing a cursory search myself online to see what's being reported by the media. As we all know, the family court reporting pilot has recently been rolled out. I quickly came across a couple of cases reporting just that, where, for example, the BBC had a recent article where one chap had decided it was a very good idea to doctor some of his bank statements. He was coming up for a variation hearing and decided that he would endeavour to reduce his income for that particular exercise. But sadly and unfortunately for him, he got found out and in fact was sentenced to 9 months in prison. Another example that I found, and we may all see the irony in this. One chap who is the head of compliance in the finance sector on the Isle of Man, in his esteemed logic, thought that he would edit emails from his estate agent, which lowered the value of the family home only by £5,000 to £10,000, so that he was then able to buy out his ex-wife when going through financial settlement. I think we would all probably recognise that was a huge risk for such a small fiscal gain. However, he too got found out and was jailed for 7.5 months. So it's quite clear from those cases, as I say, which are quite easy to come by, that people are endeavouring to try and doctor documents, and they are getting found out by the court. The court is taking the matter seriously, and it seems as though prison is a common penalty, and I'll come back to recap on that just before I hand over to Laura. But very clearly, as I say, a real issue, and I have personally had first-hand experience of this in a case that concluded last year. I'm afraid my instructing solicitor isn't able to join this evening, but I know some of her team are present and will probably have similar flashbacks when I go through some of the more interesting points of this case. But it was a multifaceted case. I was for the applicant. Not unusually, unfortunately, all too commonly, the respondent was absolutely diabolical in terms of their compliance with disclosure, pretty much from the off. The first appointment, for example, he failed to attend. He did have solicitors at least at that point, and they were present. So the hearing wasn't completely lost on that occasion. The FDR, when I was then instructed, again, he endeavoured to try and thwart that with an application for it to be adjourned. Again, the court wasn't having it. And I have to say, thanks to a very firm and strident district judge, although the FDR in the sense and spirit as we know it wasn't effective, we did get very good directions that took us through to a final hearing, but the judge being of the same mind as me that there was absolutely no point in endeavouring to repeat the exercise. and instead get closure for my client. And that brings me on to speak a little bit about my client. I have sought her permission in advance before this evening because it is a sensitive topic, and although obviously it's all anonymised, I'm glad to say that she's had some very good news recently and fed that back to my instructing solicitor and I, and at the same time said she was happy for these bits of information to be shared this evening. Essentially, my client had fled her community, her husband, her arranged marriage, which was domestically abusive in a context of honour-based abuse, and had lived in hiding for some years now in the locality due to the threats of honour-based abuse. And oddly, had continued to fund the family home, both in terms of the mortgage and in terms of outgoings, because she didn't trust the respondent to do the same. She had one friend only that was left out of her entire community who was in contact with her in a clandestine way. And she had updated my client that she also thought that the respondent husband had remarried, and that's an issue I'll touch upon again in a moment. But essentially, therefore, my client on the eve, very much on the eve of the final hearing, had no idea as to what the value of the family home was. She hadn't been able to go near it. And indeed, and luckily, the other side instructed direct access counsel at the same time, and it was agreed there'd be evaluation of the family home. That was actioned, and the upshot of that, the surprising upshot of that, was that the estate agent, on an unsolicited basis, ended up providing information and confirmation that not only had the respondent husband married, but that he had moved out, and certainly had been at least renting rooms, if not subletting the property completely. As you can imagine, that triggered a series and sequence of applications to file further statements, both from us and from the other side, which was all agreed by the judge. And at this point then, the respondent decided to try and also endeavour to make some remedial disclosure. As I say, the court allowed it all in, so you can get the picture. The scene is set, we're at a final hearing, and it's all very much at the 11th hour. We had, as I said a moment ago, already had some questions in relation to the veracity and authenticity of documents relating to the respondent husband's purported remarriage. They were foreign documents. We didn't have the expertise or indeed the means to instruct experts to explore those, and it wasn't proportionate and didn't go to the heart of the case at that stage. However, on closer inspection of this drip disclosure, which we then had, as I say, very much up to the court steps, and indeed even on the second day of the final hearing, it transpired that many of these documents disclosed were highly questionable. And I can give you a range of examples in addition to those marriage documents that I just referred to. The bank statements had an odd layout, an odd format, not something that you would necessarily immediately realise on first glance. But as we all know from the laborious task of poring over at the people's bank statements in this business, after a while, it started to dawn on me that the addresses were ever so slightly not quite in the right place. On occasion, they were upside down. And to begin with, I thought, oh, that's a formatting issue with the back. But on noticing simple spelling errors as well, questions and suspicions were raised. There were also odd emails in this case from purported previous employers claiming that our client owed them money for services. And again, on looking at these emails at first glance, they seem to have commercial email addresses, but on my searching at those same commercial email addresses, they just didn't seem to exist. And indeed, on cross-referencing the nature of these companies then with the purported emails, nothing really married. And indeed, the body of that email was worded so badly, it portrayed the fact that the respondent husband was likely writing the email, pretending for it to be coming from his employer when in fact it was from him. And the last two examples are almost verging on the comical, and updating the CV from Legal and General, for example. We all know the umbrella logo and how that sits above the wording. In this particular case, the umbrella was upside down, like an ice cream being throdged on the head of the wording. Very, very odd. And again, lastly, pay slips from Asda were emblazoned with ADSAR instead. So lots of questions were raised. Given the last minute of it all, there was nothing to do but raise all of this in bloody battle of the courtroom and put these documents to him. And that's the first tactical take home that I can give you really from this talk, which is that if you are faced in that somewhat of an ambush position, good old-fashioned cross-examination will come through for you. It amounted to hours of cross-examination in the end, and I have to say, even more judicial scolding. The particular tribunal was very, I think, principled, as well as being a good legal eagle, and they did not take kindly to this sort of disclosure. And in the course of the hearing, in fact, the respondent has been conceded a lot, but was, when flustered, not prepared to go quite as far as to accept that those documents were not the real deal. But the difficulty being, and I'll come on to the difficulty that the same difficulty that was experienced by the applicant wife in the case of X and Y. The court could only go so far in its findings, because what we didn't have was the original documentation. And therefore the judge didn't find falsification, but did cite firm concern and suspicion about the providence of the documents, and indeed highly critical of the respondent's disclosure, his credibility, and rightly found that he had already met his housing need at an awarded as cost. So a very good outcome. And as I say, heard on a very nice note recently from the client that she's managed to sell a family home now for more than she ever imagined, and is moving on in a really good way. But the case really did force me to pause for thought and think, well, how prevalent is this issue, for one? Secondly, how aware is the profession? Because I can't say that I was learning as I went on that case. And thirdly, how therefore do we and are we meant to deal with the issue? And as I say, the same questions I think very much came into the mind of His Honour Judge Hess in the case of X and Y, which dates back to 2022 now, but it is still the leading case in this area for the postscript, which I'll come on to presently. The handout that I've given you is a very cursory document. It's only 3 pages long, and I refer to the pertinent bits of law as and when we get to them. But you can obviously look at that afterwards, as and when you wish. The facts of the case were very simple. The parties, the husband was 50, the wife was 40. They'd married in 2002 and separated in 2018, with 2 children of the marriage, Z, who was 19, and A, who was 15. Neither party was a UK national, and in 2014, the husband wanted to move to the UK and persuaded his reluctant wife it would be financially worthwhile to do so. The husband told her that a company wished to buy his business for 80 million, and produce a draft sale of contract to confirm the same, plus a bank statement purporting to show that the buyer had already made a down payment of 8 million. Unsurprisingly, that was enough to change the wife's mind, and she agreed to move. The husband was in tech, he was a successful entrepreneur, and the wife no longer worked. And whilst the family, interestingly, had always enjoyed a high standard of life, the children had been privately educated. They never actually owned their own family home. And when they moved to London, that continued. They were in rented accommodation. So when the parties came to separate in 2018, the husband ceased paying rent on the family home, ceased paying school fees. By the time they got to a final hearing, the children had serious mental health issues, which the court, in fact, found had been exacerbated by the stress of all of this. And the wife was therefore the primary carer, cast adrift in a foreign country, without access to her accounts in the overseas countries, she didn't have any savings, no scope to earn, and had been saddled in addition with £300,000 of commercial debt, courtesy of the husband, and was in fact reliant by this point on state benefits. So the wife was represented, the husband appeared as a litigant in person, and his litigation conduct, again, unfortunately, a common theme, was appalling. The FDA and the FGR were abandoned and adjourned no less than 3 times each, and even the final hearing had to go part heard, due again to his lack of disclosure. The husband maintained at the final hearing that both 2014 documents, so both the contract for sale and the corresponding bank statement, were genuine, but that because the deal had unravelled, that the £8 million transfer no longer showed on his bank statement, a likely but desperate story. He also tried to assert that he had now no income and owed £1 million in tax to his home country. However, the applicant wife had done her homework. Not only did she evidence pictures from social media which captured the husband enjoying a very lavish lifestyle, critically, and this is the key to a lot of what Laura and I will be saying tonight, she had also obtained a bank statement from source for the purported payment of the £8 million. And clearly that document showed and confirmed that that transaction had never happened, or certainly had never been recorded as happening on that particular account. So unsurprisingly, His Honour Judge Hess stated at paragraph 4 of his judgment, which is where the handout begins, that he hasn't been able to reach a conclusion in this case due to the lack of full and frank disclosure on the part of the respondent husband. And at paragraph 16 and 18, he sets out as follows: on a balance of probabilities, I am satisfied that the husband dishonestly and falsely manufactured the presented 2014 bank statements to mislead the wife into moving to London. I find, therefore, that there never was a payment of £8 million, because I have reached this conclusion. I regard with suspicion the £80 million Company X sale contract. In view of the late disclosure of the genuine bank statements, there has been insufficient time to pursue the issue of whether the Company X sale contract was itself a falsely produced document, and I can make no definite finding on this. He then goes on to expand in paragraph 18(3) how, because of his findings in relation to the above, that he also has great suspicions in respect of the purported tax debts that the respondent husband was putting forward. And what he says at 16(4) is that further, when presented with evidence obtained by the wife from the internet, for example, pictures of the husband on his Instagram or Facebook account recently enjoying apparently expensive activities, the husband told me that he had deliberately photoshopped the images and that they were fake, suggesting that he thought everybody did this sort of thing on the internet. And the judge went on to say that the internet posts do show the husband apparently engaged in expensive activities such as nice holidays at the Ritz, on a private plane, Paris, Monaco, Grand Prix. And interestingly, the husband had said to Hess that many of these images were not genuine, but were photoshopped to create a false image of wealth, and that the judge, Hess, should not read too much into them. So, as I said, in relation to my case, the difficulties were there. We didn't have, at that point, the originals of the documentation, which is quite common now with electronic bundles in the age that we live in. And Hess, therefore, also had some limitations, save for the fact that they did have that original bank statement. So whilst he wasn't able to make the finding in relation to the contract of sale, he was able to cite a suspicion, make the finding in relation to the bank statement. And also, additionally, it's interesting how the judge said, due to the husband's very casual approach to doctoring, for example, his social media account, that he had overall concerns that this respondent husband was being dishonest and was providing doctored documentation. So, as a further tactical take-home point, and what clearly must have happened in order for the applicant wife to obtain that bank statement, given what I've explained to you about the fact she was being cut off in a foreign country and not able to access things. Her lawyers, although it's not contained within the judgment, must have made a third-party disclosure order to get that document, to get the original data, to put it before the court, and to make that point as forcefully as they did. And ultimately, it goes to show that even where you don't have the documentation, or not all of it anyway, just as in any other case that we might have to run, and currently, as we all know, for example, with controlling coercive behaviour, if there is a pattern of behaviour, if you stitch together enough inference, enough suspicion, you can build up a picture which is eventually so persuasive that it hangs over and overshadows the credibility of your opponent, which is what clearly they did very well in X and Y. So the outcome of the case was a very strident one. Ultimately, the applicant wife successfully argued that her application for capital claims be adjourned for a 10-year period, which again, in the profession, we know how unusual that is. But the reason being, and the court said very clearly, they were unable to identify how her claim might be met based on the information and the disclosure made by the respondent. And I think it's the second page then of the handout, which has the pertinent case law, paragraph 19, little 1 through to little 5. And clearly it's there in the first paragraph how that very judgment flies in the face of Minton and Minton, which espouses the clean break principle, and what Hess went on to say at little 5, which is underlined at the bottom. The emerging principle from the case law, which he explores in those previous paragraphs, can be summarised as follows. If a litigant engages in conduct which may include full or partial non-disclosure, which causes the court to conclude that a once-off division of capital now is likely to cause unfairness and injustice to the other party, then the court, in exception to the normal practice, has a discretion to decide that the normal desirability of finality in litigation should be overridden to preserve the possibility of a fair outcome for the parties. So it does go to show, if no disclosure, or indeed fabricated disclosure, as there was in this case, is so extensive that it disables the tribunal from being able to reach a fair and conclusive decision, a deferred application could potentially be made, as it was in this case. And whilst from our point of view as practitioners, it provides a very unattractive backstop to our clients who may find themselves in this invidious position, it does in fact provide a backstop and potentially also a highly unattractive proposition to the opposition if they don't take heed. You could put this on the table as a potential outcome. It may prove to be the carrot or the stick that galvanizes them to finally comply. So again, that's another tactical take home which you can consider further. Ultimately, as I say, the real PS or postscript to this case is what Hess was driving at. He was so alarmed, this is at the top of page 3, by what he had heard about the ability of litigants to doctor documents, that he took it upon himself to send a message at paragraph 28. And he says, one of my reasons for wishing to have this judgment published is that I wish to draw wider attention to the ability of dishonest parties to manufacture bank statements and other documents, which for all practical purposes look genuine, but which are in reality not in that category. This has occurred in the present case, and the wife has significantly suffered as a result of it. And it's important for litigants, practitioners, and judges to be aware of the issue. And then he draws the reader's attention to an article called Dodgy Digital Documents. Where are we now? Where are we going? And that's by Helen Brander. And again, the link is in the handout, so it should be easy to click on that. It's a really comprehensive article and not a dry read, as they sometimes are. And in fact, I've incidentally appeared in front of Helen Brander, who was made a district judge on the South Eastern Circuit the October before last. And in fact, had not dissimilar cases in front of her, and she is an exceptionally good tribunal. So it's clear that there is a growing professional concern, judicial consensus that this is a real issue, that we do need to deal with it. And there have been lots of calls for guidance, but as yet we don't have anything concrete. I think we will get there, and I have attached, just so you can see the way that judicial minds are whirring. There is an artificial intelligence guidance document that the judiciary launched. I think that was last October, so that is in the handout also. But in the meantime, where does that leave us as professionals? What do we do? How do we fill this lacuna? I'll give some very brief tips now, but essentially Laura's then going to lead us with the first tip, which I'll simply leave you with the headline. Sadly, we probably all need to get more tech savvy. And as I say, I'll hand Laura over to deal with that in a moment. But simply in terms of a few brief client care tips, I think all we can emphasise, as we already know, we have to listen to our clients. We also have to, on occasion, decide on balance what to run with, not to run with. Remain vigilant, and also remember that it could indeed be your client who is the person who is manipulating the documents. I have also had instructing solicitors who've had to have very frank conversations with clients for the fear that they're going to find themselves and everybody else that embarrassed. There's also case management, and in terms of some schools of thought which say you should assume every document in this current age is dodgy until proven otherwise, just simply isn't realistic. It's not proportionate. Our clients don't have the resources to take that approach. But certainly I would encourage having candid conversations with your clients, as you will anyway, at the outset of the case and as it evolves. And if you actually do end up sharing their concerns, having a very clear and well-recorded conversation on your file so that you are at one with what the approach is going to be and the extent of the resources you're going to deploy to explore these issues, because ultimately, as we know, it's all an additional expense. So the last tip from me comes back to the point that I raised at the beginning about prison. And I said I would return to it, so it's not exactly ending on a light note, but it's still a good tip from the Canny Mostyn J in the case of Baker and Baker, which is, as I say, on the last page of the handout. And what he did midway through a case where there was clearly, again, a litigant, I think he said with lamentable engagement, was that due to the questions and the bizarre and irreconcilable statements that had been submitted of contradictory evidence over a period of time, with incorrect representations being followed hard on the heels of false statements, he took the decision to order that the husband's reply to questionnaire be exhibited to an affidavit and sworn to be true. And his rationale for this was that then the husband would potentially face a charge of perjury for which the maximum sanction is 7 years imprisonment, in contrast to the maximum sanction for making a false declaration of truth on an answer to a questionnaire, which is a mere 2 years imprisonment for contempt of court. So again, that's my last take-home tactic. If you do find yourselves midway through the case and you have the benefit of time and the resources to make such threats, you may also want to consider that. But I'm going to hand over now to Laura, who, as I say, has got some practical pointers to help us with these technical issues.
Okay, yes, you'll be happy to know that Cerys has dealt with the case law. I do have a PowerPoint that Stuart is going to be my little tech assistant, because ironically, tech is not my best asset. But in terms of what I want to get out of this talk, really, is just to really look at the shock and the fear of how simple and easy it is for us to be able to create the documents that Cerys has referred to and more. As part of this talk, I'm going to take you through some hyperlinks, which are also in the PowerPoint, for you to be able to click on if you wish in due course to have a play around with. But the take home appears to be on these documents that they're held out to be novelty or joke documents. I'm not sure if I'm missing the pun of the joke, or maybe I've just got a poor sense of humour, but for us as FR practitioners, I think it causes more of a headache than a laugh. But as you will see from this first slide, it's very much my opinion, and as you've heard from Cerys, that we are living in a reality, not a myth. In terms of these novelty documents, I've provided a list here. It's not exhaustive, but you will be shocked to see just quite how many you are able to falsify. We've all seen WhatsApp messages, text, iMessages, which we'll have a look at. Cerys has touched upon bank statements being a regular issue, land registry documents, pay slips, P45, P60s, tenancy agreements, which when I was doing a little bit of research on, surprised me that you could get a full tenancy agreement. Credit score reports, so Experian, that's another one. Utility bills, and again, I'll show you some sample documents from one of the websites that I've been able to source. Flight tickets, not sure why you necessarily need them, but I thought it was an interesting one. And concerningly, when we do have cases where maybe English isn't the first language or there needs to be translation, you'll see at the bottom there, you can also make inquiries about translation documents and services. So all very scary stuff. If we move on to here is another tool that I hadn't actually come across too frequently, temporary emails. How do we deal with these? What are they used for? And you'll see there that one of the descriptions of a temporary or disposable email I provided there, a free email service that allows to receive an email at a temporary address and self-destruct after a certain time elapses. Now, having done some research in providing this talk, there are certain websites that you can actually select how long your self-destruction period is for. So that's one issue. Another issue is that you can also have temporary emails that you can access, like this one that I'll be going for in due course. But you can also link them to your own personal accounts so that emails that are being sent to that temporary account come through into your normal email inbox, so you're still able to monitor, and there's no paper trail link to say that joeblogs at tempmail.com or whatever is actually your client or the other client. Now, moving on to example iMessages and WhatsApps, conveniently, Cerys owes me 500 quid later on. And you'll see that that's been set out, and I've gone through and I've played around with a number of different websites and created both of these fabricated documents. Now, when you, and we will do in a moment, go through how those are created, what functions, and you'll be surprised at really the level of detail that you can go to when you create these documents. But again, hypervigilance, the real stress of this talk is just be vigilant. As Cerys says, we don't have specific guidance at the moment. We all need to work together collegiately to, you know, when issues come up and arise, to talk to each other about ways that people have been able to overcome certain points. And I mean, some of you may know I've got a bit of an interest in crypto, so I do quite like looking at all these different ways of being able to overcome things that are relatively fresh in the world of family law. But a couple of things, talking about vigilance before we move on from this slide, there's a couple of things that I wanted to point out, and I must admit it was only once I'd created these documents and brought my phone up. I've got an iPhone, for example. So looking at the iMessage on the left there, I'm sure lots of people have got iPhones and may even be able to look at them at the moment. But the setting of the iMessage on the left-hand side, where it refers to details, that's actually an old basis of the iMessages. If you open it up, you don't have that as an automatic default setting anymore. So again, maybe these templates aren't quite up with the time, but again, a minor thing to be able to look for. The other point as well, and again, an update in respect of Apple, is where Cerys Sayer's name is at present. So if it's a more recent message, there should be a circle with either an allocated photograph of Cerys or her initials in terms of what you're saved at. That's not there as well. So again, vigilance, looking at things, where are we now with technology? Is that mirror like for like? Is this message purported to have been sent yesterday? So forth and so forth. Moving to the WhatsApp message next to that, a couple of other points. Again, it was only on reflection when I was looking. Top right-hand corner, we can see Cerys's lovely video or photograph on her WhatsApp. Again, minor detail. When you look at WhatsApp in the most updated form that it is and has been for some time, the icon is actually in the middle of the application now, and to the right hand side you have the video call and telephone icons to be able to make video calls through WhatsApp, absent here. It is also interesting, and I didn't make the amendments to them, but where we have the message box, iMessage, there are other bits that you could put in there. I didn't change them because that is the reality of what those messages look like. So if I can move on to slide 5 and when we're looking here, so this is one of the messages or links that I use to create the message. Again, as I say, they're not really originally named ifaketextmessage.com, but you know. So in here we can insert the name. Oh, let's put Stuart in. And now here we can have messages, and look, you've even got the ability to have your read or your received bubble, your read bubble, and if it's a Apple to an Android, for example, you've got the green button. And in here, as you saw within my document, you can add whatever you want and as many messages as you want back and forth. Now, one of the things that I found interesting within this, and I think if you've got somebody trying to be tech savvy that isn't, these different colours obviously mean significantly different things. So if, for example, you are receiving something in a blue bubble when you should have received it in the grey bubble, minor things, and that's one of our little top tips about being vigilant, is making sure, and coming back to what Cerys says, is being up to date with technology as much as is physically possible. The other point in this one, for example, is that you can even select what Stuart's battery is going to be. You know, we then get into connections. So how strong is his signal going to be? Sprint. Now, this is obviously it's not a UK-based website, this one, and that was one of the points I wanted to flag to everybody, is a lot of these websites are .com. They're not always UK, and in fact some of them were limited to networks that certainly I don't think we really come across too much in the UK. So keep an eye out, because these are little things that could be, you know, forgotten if somebody's trying to, for example, trying to create a message and they've not thought about wanting to click on the connections and the settings, and you get this message and you think, hang on, my client's on Vodafone, what's Sprint, you know, what? These are, again, just tips, because the extent that you can go to, you can choose airplane mode, whether they've got 4G, Wi-Fi, and we can amend the time. So that is, for me, going to be one of my big ticket items. And it sounds so simple, but having gone through this process, and I'll come on to the WhatsApp one in a moment, is you have, and more so for WhatsApp, I suppose, but different times that you can select for the messages that were sent, the messages that were received, and the time that your phone was at the time of the alleged screenshots. So if, for example, one of those hasn't been considered in the round, it may well be relatively easy to say, well, how could a message have been sent 2 minutes before it was received? And small things in that sense. We can even, and I touched upon it a moment ago, you can have text message, iMessage in that bottom box there. You can black the name out, and you can have the choice of having your microphone or your screen lock on. So again, really straightforward, and probably the most petrifying part of it is click create image, whether or not, there we go, Bob's your uncle. That was that straightforward. And then what you do is we download that, and as you'll have seen within my talk, within the handout, I just created it into a PDF, and that was it. So that's the way the iMessage is. I'm just briefly going to touch onto the next one, which is the WhatsApp. Again, really creative, fakewhats.com generator. Now, we've got the same principle in this respect, and in fact, actually, so as it is with the iMessage, we can amend it as we go and even get a little preview of what our message might look like. Not sure what this default is on the website, but and as you'll have seen, I was able to upload Cerys's WhatsApp image. The clock time, you can have different messages. So for example, I changed my one because I had a look at how the WhatsApp formula is, and might not think to do this, but that's not normal. What it will either say is messages, or it will have a number in terms of how many messages that you have unread for WhatsApp. And again, the same points are raised in this respect: battery options, connection, and messages. And actually go as far in WhatsApp, you can create whether you've got a red tick, delivered tick, sent tick, or none. So it really is feeding into this idea of, well, of course, this is pretty genuine looking, isn't it? We've got the blue ticks, we've got, you know, me responding to say thanks for my 500 quid back that I loaned you, Cerys. You know, you can imagine, for example, in a loan agreement case where somebody's saying there was never an agreement for a loan. Thank you very much. Let's set up a nice WhatsApp trail there that between the two of us says, yeah, we don't have a signed loan agreement, but you know, these messages are pretty clear. You were going to pay me back by this date. I acknowledge that. It's just an example of how this sort of technology can create us headaches. So going back to our other slide, it takes me on to bank statements and other documents, maybe slightly more scary. Now, apologies, there is a cost to most of these, so I didn't put money in my, have my hand in my pocket to get the documents in terms of real live examples. But the link Stuart will click on in number 6 here. So again, ingenious names, fakebankstatement.com, replace your docs. If we can go to the top link, which is fake bank statement, again, a little bit daunting, I thought, in terms of the extent of, and I briefly covered them on my first slide. But here we can see, so not only does this particular website deal with the UK, if we have clients with international banks, for example, Bank of Ireland, obviously Amex is a big one as well that we probably come across quite often. But look at the, you know, the plethora of different types of bank statements, Revolut, which at the moment is something that is being used more and more often, Monzo, the Starling saving accounts, pay slips. Cerys has obviously come across that already in terms of not even being able to spell Asda right. So these errors do come up and do happen. Lots of Starling. You can even get your P60s and P45s. Utility bills, and as I said, we've got tenancy agreements, and quite helpfully, this particular website, you'll see as I'm cursing over them, you can even click on them to get your samples, pretty straightforward. Some of them they want you to pay for, so obviously that really is just that straightforward. And I found it quite alarming, and it took me a step back that actually I think as practitioners, we need to shift our mindset from a default that is, I've got a bank statement there, that might be, maybe that's the way it was scanned. Maybe there's a blur there, or as Cerys said, one address was upside down because of the way it's scanned. I think we need to just, rather than that maybe being default, is just have that inquisitive of, is that the case, rather than just assuming that it is. Moving on to the next link, this one, this was replace your docs, which again, I wanted to provide you with because these actually give you samples, and I wanted to look really at energy bills and utilities. Look how realistic they are. obviously with the removal of sample. But BT, as a BT customer myself, that is when I download my BT accounts from my app, that is the PDF that I get. It is really astonishing. British Gas, that's another big one. EE, so we can, our phone records as well, energies, and so forth. Look, it's just the list. Oh, you even got some coming soon, some more ones. So again, these are things that it's not just limited to messages and bank statements. These websites, these joke documents, as they seem to be putting themselves forward to be, really are pretty persuasive. Which takes me on to my next slide. How much is this going to cost me? If, for example, Joe Blogs wanted to obtain one of these statements, and I've taken it from the Trusty Fake Bank Statements website as an example here. So on the left-hand column there, we've got a range of bank statement prices, so summary pages as such, but we can see throughout that, you should get a quarterly statement, no problem. 6 months, no problem. 10 months. And most importantly for us here, the 12-month package. Because obviously in terms of formies, that is something that we need to be alive to. That not only can it be short periods or the odd statement here or there, actually these websites are providing abilities to provide a full 12 months, which will take me on to the point about we all need to be considering when we've got this at the early stages. I know what Cerys was saying about some of the cases that had been reported and the one that she found herself in, time had already passed almost as such. We need to be thinking about this from voluntary exchange. We've got price lists there. And then on the right-hand side is some of the utility bills and things that I went through on the other website, flight tickets. But right at the bottom, and I touched upon this earlier, translation services, price on request. So not only are these websites doing your set packages for some of this information, they're even opening the door to say, we actually got some products here that we can tailor to you and price you, cost you and charge you accordingly. And translation services, for me, that really concerned me, because to be able to have fabricated translation documents is an issue in terms of interpretation when we have court-appointed interpreters, because I personally, and I know my solicitor is on this on one case that we had where we had a interpreter conflicted. So what happens when we arrive and, for example, the translation service documents, the court, they're going through in mid cross-examination and the translator has to go, that's not actually what that says. But no one else in this court would know that because we're not privy with the expertise and tools to be able to know that that's not what what that means. Really, as I say, sorry, a bit of doom and gloom there, but something that I thought we need to be alive to going forward. So moving on from prices and costs, as you see, it's not actually that expensive either. If somebody really wants to do this, do it properly, it's not even that bad. The other point I would say of interest is, and this is something that I am going to do at some point, I will put my hand in my pocket, because I would like to see how these transactions, when you purchase a bank statement, is recorded on your own actual bank statement in terms of what is the reference that's used, what's the accounting, because again, and I say, sorry, I wasn't able to do it now, but I can certainly do a follow-on if it is something absolutely ludicrous, and I'll add it to my list of alarm bells, keep a lookout. Some of you may have come to my crypto talk, and we did that very point in terms of there was a specific crypto asset that labelled themselves as Swissborg, and the usual you don't have a bloody clue really what that is. So again, I will update everybody in that respect. But just turning to the next slide, as a financial remedy practitioner, we all have to deal with the FPR, which sometimes is a blessing and a curse. The family courts being slightly behind the curve, and maybe adopting an approach that isn't the way that the civil courts consider, and that is electronic documents. And I only raise this for interest in and maybe having it out there to see whether or not we will get something in the FPR that is akin to this. But specifically, so 31B6(4), electronic documents should generally be made available for inspection in a form which allows the party receiving the documents the same ability to access, search, review, and display the documents as the party giving the disclosure. Now, the reason I raise this is because I think we've probably all had cases where, for example, if we're running conduct or even Section 25 statements where we receive the evidence from the other parties and it's effectively just exhibited into a witness statement, put into either copied and pasted into a Word document, so that, similar to how I've done with that cost schedule a moment ago in this PowerPoint, you don't have the original metadata from that document. And I will talk about metadata in closing in a moment, in the hope not to bore everybody too much at the end. But we don't have access to those. So one of my points that I think that we as practitioners should be more not only open to, but not worried to ask the question for, is asking for the original documents, whether that be photographs, whether that be bank statement, or whether that be any other form of PDF document or exhibit that's provided. Because clearly civil practitioners are switched on to something here, that there needs to be parity between those providing the disclosure and those receiving it. My final slide, really, what do we do, where do we go? And as I've said, a theme throughout this talk has been hypervigilance and working together. I think I've come across or really dealt with a fair few of these things to think about. Third-party disclosure orders, don't be afraid to ask for them, especially at an FDA if you've got suspicion and you're able to back up that suspicion with some form of evidential basis as to why, not just my client thinks that Joe Bloggs has got 60k in an account somewhere and that's the end of it. But if there is some suspicion when you're looking at these bank statements, something's not quite right. Another factor is Adobe. You can actually edit on top of Adobe. If you've got PDF Adobe Maker, there are editing softwares on that, but those are stored if they are modified within the metadata. So request third-party disclosure orders at first point if you can. But if you're faced with a plethora of messages on a preliminary issue, for example, that suddenly have cropped up, that goes and it's their golden nugget to prove their issue, and your client's going, I never sent that text message, I haven't done this, I haven't done that. WhatsApp will be slightly more difficult, but obtain phone records in terms of when were messages received in and out from what number. You know, if that is the case, let's ask these prying questions. And whilst we of course have to placate our clients to some extent and reality check them, if you do have a client saying, I'm telling you, that has never come from my telephone, that is a way to be able to obtain those records. And those are easy because you'll be obtaining your own client's telephone providers. So from your own provider. So there won't necessarily need to be orders in that respect. You can just go and obtain that from your client or ask your client to get them. Land registry documents. This is quite a straightforward, simple one, to be honest. We can get the official copy entry. So if you've got some suspicions in terms of any land registry documents that have come your way, I've actually had a case recently with a very fishy TR1, and we have requested the office copy entry for that. And lo and behold, the property was not held as they were asserting it was held in the document. So again, look forward to pushing that one when it comes in for FDR. Company's house, again, it might sound really straightforward, but if these junk novelty providers are pushing this out in terms of being able to provide tax information and you just think this isn't sitting right, always worth double checking on Company's House for businesses and whether or not the accounts that are available at that time marry up with anything that's provided. And then a couple of the other ones which are really just a little bit more back to basics, and I think I covered them when we were going through the hyperlinks, is tech savvy. I think looking at a document, not just seeing it, that's something I have to tell myself quite a lot. And I think as financial revenue practitioners, we go through so many bank statements, you know, reading codes left, right, and centre. There's so much information that I think sometimes we can see documents, but not properly look and analyse them. So taking this moment to just double check if something goes off in your head is not quite sitting right, just to take that moment to breathe and reassess.
Professional curiosity is a good.
Professional curiosity is a good thing, as Cerys says, absolutely. So and my final point, I put font sizes. I put that under messaging, but actually I think Cerys made a good point in respect of bank statements. Those are really, as I say, we don't have guidance yet, but I think if we can all help each other and start thinking creatively and really all of us, whether you are this side, as Cerys said earlier in her talk, the side that is suspiciously providing documents that you might not think are accurate and true, or whether you are the other side going, no, this doesn't compute. And I think we all need to work together as a whole collegiate to try and set some markers down as to how we can continue to identify and deal with this. Because as I mentioned earlier with the 12 months, we need to ensure that the entire financial remedy system is not entirely undermined. The whole disclosure basis is not undermined by these fabricated documents coming out.
Fantastic. Excellent. Okay, thank you very much, Laura and Cerys. If anyone has any questions, please do either pop them in the chat, please do email them to family@Westgate Chambers, and or by all means log on now if you're able to and ask our experts. But other than that, if we don't hear anything from you, that will be the end of today's seminar. Thank you very much for joining us.